Good evening, everyone. Thank you for your patience. We are now going to call the Board of Appeals meeting to order at 5:34 p.m. We have present Kara Espera, John Tutenhoff, Stephen Isaacson, and Wendy Smith as chair. This meeting has been properly noticed and posted according to law. And now we will move to item 4, consideration of the meeting minutes.
Good evening. Is my microphone on? Does it sound on? Possibly. Maybe it's just low. Testing. That's better. Item number 4, consideration of meeting minutes, June 11th, 2024. I've been advised by the clerk that the meeting minutes require an edit. So if there are no objections, I'd like to defer consideration of those minutes until our next meeting next month. Hearing no objections, those minutes are deferred. Moving forward, item number 5 is when we go over the legal standards that apply to the items we have on our agenda. And in lieu of no village attorney present at this meeting, I'll state the legal standard that we've been advised by Village Council to use for the various items we have on this agenda. I'll do that as we come up on each agenda item. Starting with item number 6, which is a request for a variance of Village Code 225-8B sub 2 to construct an 8-foot tall fence within the front setback area at residential property 4442 North Lake Drive. This is a request for a variance. The Village Board of Appeals may hear appeals from persons aggrieved by any administrative order, decision, or determination, and may hear and grant applications for variances or other exceptions to our municipal code. For a variance, in consideration for a request for a variance, the board may hear and grant an appeal, such as that appeal will not be contrary to the public interest, where owing to special conditions, literal enforcement will result in practical difficulty or unnecessary hardship, so that the spirit and purpose of our municipal code and zoning will be observed, and the public safety, welfare, and justice will be secured. Specifically, in order to grant a variance, the Board of Appeals must find the following, and these are 2 elements. 1, and this is pursuant to Municipal Code Section 535-58. There must be exceptional, extraordinary, or unusual circumstances or conditions applying to the lot, parcel, or structure that do not apply generally to other properties in the same district, and that granting the variance would not be of so general or recurrent of a nature to suggest that the municipal zoning code chapter should be changed. And the second element that we have to find is that the variance will not create substantial detriment to adjacent property and will not materially impair or be contrary to the purpose and the spirit of the municipal zoning code chapter or the public interest. So in summary, we're looking for exceptional, extraordinary, or unusual circumstances applying to the property itself that would justify granting of a variance and showing that there's no detriment to neighboring properties and things of that nature. So in consideration, the materials for item number 6 relating to residential property 4442 North Lake Drive begin on page 4 of the agenda packet. How this will work is that we'll first ask for a statement from the village to describe the request, and then we'll allow the applicant or the owner of the property to make a statement if they wish. So we'll start with a representative of the village that would like to make a statement relating to this request for a variance.
Inspector, I'm sorry.
I don't know that we have the applicant for this item.
Could probably ask, is there a representative of the residential property 4442 North Lake Drive?
Oh, thank you. That's
them.
Okay.
Yes.
Well, then I might need to repeat my spiel.
Thank you.
Hello, for our attendee on Zoom, are you able to hear us?
Yes, I can hear you. Can you hear me?
Yes. Are you the representative relating to property 4442 North Lake Drive?
Yep.
Okay, great. Well then, We are going to consider the request for variance relating to the property 4442 North Lake Drive. I will repeat the legal standard that I just described before letting you into the Zoom call. In considering a request for a variance, the Board of Appeals may hear and grant a variance upon finding the following criteria. The Board of Appeals may grant an appeal such as that it won't be contrary to public interest and where owing to special conditions, literal enforcement will result in practical difficulty or unnecessary hardship, so that the spirit and purpose of the municipal zoning code shall be observed and the public safety, welfare, and justice secured. Specifically, to find cause to grant a variance, the Board of Appeals has to satisfy two criteria. One, there must be exceptional, extraordinary, or unusual circumstances or conditions applying to the lot, parcel, or structure that do not apply generally to other properties in the same district. And the granting of the variance would not be of so general or recurrent of a nature to suggest that the zoning code chapter should be changed. The second element is that the variance will not create substantial detriment to the adjacent property and will not materially impair or be contrary to the purpose and the spirit of the municipal zoning code chapter or the public interest. So in consideration for this request for a variance, we'll start with a statement from the village, followed by an opportunity for the homeowner or representative for the homeowner to make a statement as well. So we will begin with a statement from the village.
Inspector Burris, can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes, so the property owners of 4442 North Lake Drive are requesting a variance to construct an 8-foot tall fence or gate in the front yard of their property. The village received the building permit application on August 4th, 2023, and the Board of Appeals application on June 24th, 2024. So approximately a year later. The building permit application was initially denied. However, the owners decided to proceed with the construction of the fence, which is 4 feet and compliant, and hold off on the gate portion until this time now. The applicable zoning regulations are that all fences erected or constructed in the front setback area in compliance with 53519 shall be limited to a height of no more than 4 feet. The front setback is a minimum of 25 feet or the average on the setbacks of the side of the street where the property is located between two closest intersecting streets, whichever is greater. The proposed location of the gate is less than 25 feet from the property line, according to the survey on record, which would place it in that front setback area and limit the height to no more than 4 feet. Within the packet, we have their building permit application, the original denial letter, the plans that illustrate the gate, and their Board of Appeals application with their explanation.
We have questions for Inspector Burris at this time. Inspector Burris, it appears that the fence has 2 gate posts alongside the driveway.
Yes.
Are those conforming as well?
So, yes and no. Yes, in that, so those are structures and not necessarily a fence. So they're not, it's complicated in that regard that, yes, can you have, say, a pillar that is greater than 4 feet in height? You can. But I guess it's, yeah.
So the issue for us to decide here is only the gate portion that would go in between the 2 existing cement or stone posts.
Yes.
Okay.
Yeah.
And if it's okay if I clarify, those were installed by
Hold
the
on just a moment. Just a moment. You'll have an opportunity to explain once we swear you in during the homeowner's testimony portion. So just hold for a moment and we'll give you an opportunity to explain. Other questions or clarifications from Inspector Burris? And if I'm understanding this correctly, the proposed gate is around 8 feet tall. Is that correct?
At the highest.
At the
point,
highest.
yes.
Okay,
Mhm.
great. Hearing no questions for Inspector Burris at this time, let's proceed with the homeowner or the homeowner's representative. Our clerk will swear in the homeowner if they wish to provide a statement, and then we'll have an opportunity to ask questions.
Carolyn, can you turn your camera on, please?
Yep, no problem.
Thanks. Thank you. Can you raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thanks.
So can you provide us with a statement that would explain the need for this gate? Taking into consideration that we need to find something special or extraordinary about your particular property that would justify not complying with the zoning code as it is.
Yeah, so we are located on a curve. And within the last couple of months, so since March, our property's been hit by drunk drivers 2 times in the last 90 days, which includes one that was overturned in our driveway. So that's a very big safety concern for us. The second piece of that is that the pillars that you were asking about, those were pre-existing on the property and constructed by the prior homeowners. So we were trying to incorporate them in a way that respected the historical aspect of the home. So that was another piece. And then the third thing was, with the fence, we've complied with the 4 feet height, and we're able to do that with also providing the adequate privacy and protection with trees. We've also had issues with trespassers on our property, people just coming through our property, going straight to the backyard, things like that. And so, with the fence itself, we're going to plan to put some trees behind that to also try to prevent trespassers. But with the gate, we can't do that because cars need to go through there. So.
So is it your statement that the 8-foot fence would act as a stronger barrier to, say, car collisions than a 4-foot fence?
Yes,
I'm trying
and
to understand
pedestrian.
for the
and
8-foot
pedestrian-
fence as opposed to a 4-foot fence.
Yeah, especially also for pedestrian trespassers as well.
Is there direct access to the beach area behind your home? Or is there something else that's enticing individuals to step onto your property?
Yeah, so we have a lake view and we have a stairwell that goes down towards the lake, and that's been an issue that we've encountered.
Questions for the applicant from other members of the board? Hearing none. Is there any additional statement that the applicant would like to make to the Board of Appeals before we transition over to deliberation?
I don't think so. I think the only other thing was, I don't know if Toya included in her packet, but the adjacent property emailed voicing their support for the higher fence, just to the extent that that may not have been included. So,
I believe it is included. I saw that email from the neighbor.
okay, yeah, then I have nothing else at this
And
time.
that's helpful information too, to know that the adjacent property, at least one of them, does not object. Okay, last call for questions? Hearing none? Can I have a motion to close the testimony period of this matter to enter into consideration? Do I have a second? Thank you, John. We'll move into consideration. So testimony is closed now. We'll talk amongst ourselves to see whether we have enough to justify granting of a variance here. Do we have any initial thoughts on whether we find exceptional, extraordinary, unusual circumstances that would justify granting of a variance?
The house is
I believe that we've had similar properties in the past where we have granted a variance where homeowner has shown that there have been people hopping fences to try to gain access to the beachfront areas, given the special location of those properties, and especially if this property has kind of a staircase that leads down to the beach. That seems like a extraordinary circumstance that might justify a higher gate area than the 4-foot requirement. For our second element of detriment to adjacent property, it doesn't appear that this tastefully designed gate would impose a substantial detriment to adjacent property for me. But any other comments? Ms. Crivello, do you mind providing us with some information on whether the gate is electric or manual?
It's going to be electric, so there would be a gate for someone to request access.
Okay. Thank you. Further thoughts on whether this meets our criteria for granting of a variance? Any other comments, or are we ready to proceed to a motion to vote? I'll make a motion. I will move to grant the request for a variance of Village Code 225-8B sub 2 to construct an 8-foot tall fence within the front setback area at residential property 4442 North Lake Drive as meeting our criteria for granting a variance, and that we find exceptional, extraordinary, or unusual circumstances applying to this particular property, and a lack of any substantial detriment to adjacent property. Toya, do I need a second on that?
Yeah, I'll
No,
second.
thank you, Kara. Toya, will you call a vote on this motion? And again, this motion is to grant a variance.
Moment, let me just note Karis. Okay. Stephen Isaacson, John Tutenhoff,
Aye.
Wendy Smith,
Aye.
Kara Espera.
Aye.
Motion carried 4-0.
The clerk will provide notice to the homeowner that the variance request has been granted. Thank you for your time.
Thank you all very much.
All right, moving on. Item number 7 in our agenda packet, request for a special exception of Village Code 535-9G regarding maximum lot coverage at residential property 4205-07 North Prospect Avenue. This is a request for a special exception. I'll go over our legal standard for that particular type of request. Again, the board has authorization to grant certain special exceptions to our municipal code. In consideration for a application for a special exception, pursuant to Municipal Code Section 535-34E, subject to the provisions of other applicable state law, the board may, upon an application, grant a special exception to the provisions of subsection A of the municipal code. This is relating to non-conforming structures after considering the following elements. A, the effect of granting of the exception will have on the appearance or character of an applicant's property, adjacent properties, and neighboring properties. B, the effect of granting of the exception will have on the value of the applicant's property, adjacent properties, and neighboring properties. Whether the granting, subpart C, whether the granting of the exception will serve the public interest in improving and preserving the value of property. And D, such other matters as the Board of Appeals deems relevant and material. All right. So we'll begin here with a statement from the village. Inspector Burris, can you provide us with a summary of the request for special exception for this property?
Yes. So again, the property owners are seeking the special exception to expand the legal non-conforming lot conditions by installing a rear yard patio. The applicant would like to construct a 15 by 20 foot rear yard patio adjacent to their attached garage. The lot is 5,295 square feet, which requires a minimum of 1,588 square feet of open space. However, currently, there is only 26% open space, again, making the lot coverage legal non-conforming. The additional patio area would result in a reduction of 6%, leaving approximately 1,084 square feet. The applicable zoning regulations are 535-9G. At least 30% of each lot shall remain as open space, uncovered by structures and planted with grass, shrubs, trees, or other forms of vegetation or surfaced with natural ground cover. Again, non-conforming structures as in the patio here. No structure shall be expanded or enlarged if such expansion or enlargement will add or increase the degree of nonconformity unless such structure is made to conform with the regulations in which it is located. And then again, the Board of Appeals has the power to grant an exception to that. One comment that just as a point of clarity here, the open space requirements in 535-9G are put in place specifically for aesthetic reasons. It is not about permeable surface area. So it is not a concern that we are concerned with drainage in that things are pitched so as to not push water off onto neighbors. But the open space requirement was put into our ordinances for aesthetic reasons and none other. So again, within the packet, we have their building permit application, the denial letter, the Board of Appeals application, and the maps and the survey of the property.
Thank you. Questions for Inspector Burris?
I'm just looking at the packet. Which house?
I believe it's a duplex 4205 and 4207.
Okay. Thank you.
It doesn't exist.
I was like,
So for clarification, are we going from 30% to 20% if with the proposed
We're going
patio?
from 26 to 20.
Oh, I see. Okay. So
Yes.
when the 26 is the legal non-conforming. Okay.
I want to say we are, so the patio itself is 300 square feet.
And it appears from, I'm looking at the aerial photo on page 33, that there is there currently grass as depicted, and this might be better question for the homeowners, but is there currently grass as depicted in the property or on the aerial property photo on page 33?
That is my understanding, yes.
Okay. Other questions for Inspector Burris?
Yeah, so just to reiterate that this isn't an issue with the drainage.
It is not, no. So we still consider that and look at through the building permit and installation of things that it is pitched appropriately so that it's not pushing water onto adjoining neighbors.
Right,
Yes.
but going from the 26 down to 20, that's an aesthetics.
No, it's just that, so the 30% open space requirement was designed so that properties would have some amount of natural vegetation,
Okay,
plantings and things like that, in that it looks nice, right? However, there are, as we all know, the lots are small and there are certain areas of people's yards, depending on what side the garage is, where grass doesn't grow very well, and it's not necessarily any more attractive to have a, haphazard lawn than it would be to have a patio.
What, just curiously, what is layman's term, the negative repercussion? Other than.
Stephen, do you mind speaking into the microphone so
sorry.
that when Toya is recording this,
Yeah,
she can hear
I'm
you?
trying to understand what the negative implication would be relative to aesthetics or neighborhood or neighbors. What would the impact be by granting this that's different than what exists?
Sure. So I guess if you kind of took it down the road of, let's say we had no requirement for open space, and people just started saying, well, we just want to pave the lot because then we don't have to maintain it. You could just have, paved lots everywhere. And that might be seen as unattractive.
So in the case of this, what is by granting the variance, how much actual space are you granting that might have a negative impact on the aesthetics? I don't know if I phrased that correctly, but
Sure.
we're
So
talking about a technical situation that is within code, and you're asking for a variance to do something else. And what I'm trying to understand is whether that something else changes the nature, the character, the aesthetics, the landscaping that neighbors or the village might find.
Mhm. So I would say that in just one, again, point of clarification. So here is they're requesting a special exception. So we're understanding that the property already does not conform. That the lot is already beyond the acceptable amount of lot coverage. With that said, the difference of the example I just gave, everyone, in the neighborhood just decides, well, I want to blacktop my lot because it's easier, versus someone installing a patio that would, again, be more attractive than an unkempt lawn, where grass doesn't grow very well because it's on the shady side of the garage. So in certain instances, you could say that this is actually more attractive than the option of this, open space requirement.
So again, for clarification, there is no existing patio in that area currently.
No, so we have looked at this as, again, the expansion of structure, because they have, say, like the concrete drive and things there, that we're just kind of expanding that area.
Okay.
So one further question then. So if you don't grant the variance, does that preclude them from putting in a patio?
It would, yes.
I just have a question, since we're looking at a special exemption and not a variance. And the
Yes.
standards are different. And these seem to really consider value, both in the house, the neighborhood, public interest, all that. Do you have any information related to having a finished patio versus having this, and what? 'Cause that kind of seems like a subjective thing to me. I was just asking whether, we have any information regarding what the patio increase the value of a house more than increased green space, because it just seems like a subjective thing.
I'd say with value, it's probably has little to no impact one way or the other. And because it is such a small area, I would just come back to me, point A of the special exceptions, the effect of the granting of the exception would have on the appearance and character of the applicant's property, adjacent properties, and neighboring properties. And I believe the homeowners may be able to speak a little bit more to that part of things. Yeah, the effect the granting will have on the value of the applicant's property, and adjacent properties. So, again, my understanding is that they're looking to make an improvement, right? To the property, and that if anything, it would likely increase the value, and not decrease. And again, at any point, if someone wanted to return it back to vegetative or, open space in that respect, it's a pretty easy thing to do.
Any other questions for Inspector Burris? Do we have a representative from the homeowners that would like to make a statement? If so, please approach the podium. And again, as a reminder, please speak into the microphone so that we can capture your voice. Your choice. We can certainly swear in both of you, but if you'd like to elect. Okay.
It's a faithfully affair.
Can you both raise your right hand? Thank you. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And can you please provide your full names?
Randall Scott Chappa, my wife Teresa Chappa.
Okay. All right. If you can please provide a statement, maybe tell us more about the project and the need for the patio so that we can understand whether this type of improvement, how it's going to perhaps improve the property value of your home, any other information that we can consider in whether to grant this special exception.
Right. Right now, the patio is an unusable space. It's very small. It's actually in a depression where water from the neighbors on all sides get into this. And you're right, the vegetation doesn't grow. It's just a plot of weeds. So what we're planning on doing is putting a beautiful patio that one would definitely improve the value of the house. Because right now you go a bit into the backyard and it's mud. So it'd be great to have a patio there. Secondly, with the adjacent properties, it's basically, you can't see it from the street. Where to the south is a garage, our garage. To the west is a 6-foot fence that runs the path of the neighbors. So there's no contact there. They won't even see anything of that area. And to the north is another garage. And what we've done and what we plan on doing is creating beautiful flower gardens around the perimeter, which would still definitely increase the value of the property. And it'd be a great, enjoyable space out there.
Because currently we have no space at all to sit outside. The front yard is very, very small. So we have no place to sit out front at all. And this is our project house. We spent 4 years on this house. So trust me when I say we're not going to do anything that's going to devalue the 4 years of labor that we've basically have completely restored this property. For the last 4 years, Justin's been in there and Tim's been in there many times. So they could contest to the labor of love. So we really would like to have some space outside to be able to have a grill and a table to eat outside. So that's really the main goal. But I don't know, I take care of the property next door. So if you need proof of our yardscaping capabilities, I can send you lots of photos.
All right, questions for our homeowners?
Do you guys live at the house currently? And it's the 4207, is that rental property then, or is it?
That is correct. 4207 is a rental. We live upstairs is 4205, where we live.
No, we live at 4207, the rent is 4205. Sometimes, you know.
She's correct.
And the patio is not going to serve as a extra parking spot for then anybody, or?
No, it's not going to serve as a parking spot. It'll be with furniture and a grill.
Will there be any remaining green grass turf area in this proposal, or will the entire backyard be paved over or some type of stone material? Is there going to be any type of lawn covering at all back there?
Lawn, no, but nice, beautiful flower beds.
Okay, and
Along
so
the perimeter, about 4 feet from our west end of the lot, all the way to the start of our rear of our building. So it's a long stretch that will be flowers.
okay, so along the, if I'm looking at the
The
map
north
correctly, and I have a hard
side.
time with the compass, but the north side of the
Mhm.
property and the west side of the property will still have some landscaping material.
Absolutely.
Okay. All right. Further,
Yeah, just
Questions?
one. Is the downstairs rented now?
It is.
Have you had conversation with the tenant about?
Absolutely. They're all for it. They would love someplace to go and back as we do or would do, to enjoy, you know, a grill out or some
It would
outdoor.
be available to them as,
Absolutely.
thank you.
It doesn't, I don't see any material within the agenda packet showing that any neighboring properties have objected to this request. Is that true, Toya?
That is correct.
Okay. All right, any further questions for the homeowners? Hearing none. Any final statement you'd like to provide to us?
It's going to be beautiful.
All right, well, thank you for your statement. I will move to close testimony portion for this item and proceed into deliberation. Do I have a second? Okay. Given that our criteria here is we're looking for the effect of granting an exception on the appearance and character of this homeowner's property, any adjacent properties and neighboring properties, including any effect on property value. Whether granting the special exception will serve the public interest and improve or preserve the value of the property or in any other matters we deem relevant and material. Do we have any initial thoughts on whether this property meets that criteria for granting a special exception?
Well, knowing these lots and everything else, yeah, I can see how small the lot is already, and not like they haven't. Two. Already put it at 26. A lot of room for them.
I tend to agree that if we want to be able to use the backyard space for things like grilling or outdoor eating or just, you know, convening with friends and family, that the applicant's testimony that the turf area is currently kind of a not very hospitable area to entertain or use, that a patio with the proposed landscaping would be an improvement to the property generally.
I think also, seeing as how there's a tenant situation, it's obviously investment. I could see where the patio is. Future renters, if there should be any business.
Any further comments? All right, are we ready to proceed to a motion? I don't mind making a motion again. I will move to grant the request for a special exception of Village Code Section 535-9G regarding maximum lot coverage at residential property 4205-07 North Prospect Avenue as meeting our municipal code criteria for granting of a special exception, in that we find generally that the patio as proposed with landscaping will serve to improve the property value and improve or preserve the homeowner's use and enjoyment of that space. Do I have a second?
I second.
Toya, can you call a vote for that motion?
John Tutenhoff,
Aye.
Wendy Smith,
Aye.
Stephen Isaacson,
Aye.
Kara Esper.
Aye.
Motion carried 4-0.
The clerk will send official notice of the granting of that special exception. Thank you very much. All right, moving briskly along to item number 8. Request to appeal the village's interpretation of Village Codes 225-6 and 415-18 at residential property 3515 North Murray Avenue. This is, as we've had recently, a request to appeal the village's interpretation as relating to the downspout disconnection program, I believe. Let me make sure I'm saying that correctly. right, so this is beginning on page 34 of the agenda packet. Let me make sure this is the right address. Yeah, 3515 North Murray Avenue. I will go over the legal standard, but first, we've been previously advised by our village attorney that the appropriate mechanism for the Board of Appeals to hear a challenge to the downspout disconnection program is through not asking for a variance and not asking for a special exception, but what we call an appeal to interpretation to allow, which is a different check-marked box on the Board of Appeals application. So the appropriate way for the Board of Appeals to be able to hear this matter, if this is actually an appeal to interpretation to allow, which is essentially saying that the applicant disagrees with the village's interpretation of the code. So I notice you'll see on page 39 of the agenda packet, we do have a Board of Appeals application spanning through page 47. And in these applications, variance has been checked. So for a preliminary matter, I would like clarification from the applicant who is seeking to challenge this decision to confirm whether they are seeking a variance or whether they are seeking an appeal to interpretation to allow. For that preliminary question, is there a representative of the property that can come up to the podium, please? Can you swear her in briefly so that
Yep.
we can get to the, yeah.
Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you.
And can you clarify your first and last name, please?
Pardon?
Your first and last name.
Oh, it's Judy Spencer.
Thank you. So I know that filling out the Board of Appeals application can be confusing. So we just want to make sure that we're able to hear this. You've checked variance, but the appropriate way for us to be able to hear this is if this is really an appeal or interpretation to allow, which is that you disagree with how the village has interpreted the code. Is that correct?
You know what, I'm really confused by what you're saying.
I know.
You know, I don't know how to answer that. I just don't want to disconnect my north downspouts. So I'm not sure.
Okay, I'll phrase it a little bit differently. In order for the Board of Appeals to make a decision on whether the village has made the right decision here to order disconnection, the request has to be an appeal to interpretation to allow. And that's kind of a legal phrase. But essentially it means that you disagree with how the village has read and interpreted our municipal code when they decided to order disconnection. If this proceeds as a variance, we do not have the jurisdiction to hear the request because it needs to be an appeal to interpretation to allow. I'd like to clarify at the onset, if you are asserting that you're appealing the village's interpretation of the code relating to your property. If that's the case, we can proceed.
Okay, well, let's just do that.
Okay.
Because it still is very confusing to me.
Okay.
I'm sorry. I don't know.
No, that's perfectly fine. I just want to make sure that we are in the right category of legal review so that we can proceed. If that's
Okay.
what you're saying, you disagree with their interpretation
Okay.
of the code, then we will proceed
Okay.
as an appeal to interpretation to allow.
Okay.
I'm sorry for
appreciate
the
that.
legal jargon. I'm sorry.
Yes.
For the time being, you can have a seat again. I'll have the village make a statement relating to this request. I will highlight to the board that we have previously heard from village council as to the criteria that is found on page 34 of the agenda packet, the zoning regulations relating to downspout disconnection. Okay, so we've previously been advised by the village council that the appropriate legal standard for us to review this particular type of challenge is that our standard review is not de novo, but instead a deferential review to the inspector's decision. And essentially what we're looking for is there substantial evidence to support the inspector's conclusion. In the case of downspout disconnection, we're looking at whether the inspector had or the village had substantial evidence to support an order to disconnect downspout. On page 34, we do see the Milwaukee Municipal Sewage District, MMSD.
Milwaukee Metropolitan Sewerage District.
There we go. The criteria listed on page 34 and 35 relating to when disconnection should be ordered. We'll proceed now with a statement from Inspector Burris, who could probably more eloquently explain what the disconnection requirements are. Inspector Burris.
Yes, thank you. We'll again start here, just that Shorewood's Combined Sewer Service Area Downspout Disconnection Program was adopted by the village board on February 2021 and identifies the process by which the village needs to comply with the MMSD rule. The owners, on March 6th, 2024, the village issued a downspout disconnection notice detailing the requirements, along with a report from Strand and Associates indicating which downspouts in this specific case were required to be disconnected and which were permitted to remain connected. And the notice provides until November 1st, 2024 to complete the required work. The owners emailed the Department of Public Works on May 13th with the request to grant an exemption to the notice they received. After visiting the site, the DPW director notified the property owners that the program requirements had in fact been met with respect to the available area to discharge the downspouts and that an administrative exemption could not be granted. On June 12th, 2024, the village received the Board of Appeals application. Again, for structures, let's see, here. I'll just read this. For structures that contain up to 4 residential units, the connection of roof drains to combined sewers is prohibited after January 1, 2025, when the following conditions are present. Again, unless disconnection would cause property damage or unsafe conditions. And those are: the roof drain is external, sufficient space is available to locate the discharge point at least 5 feet away from basement or foundation walls and property lines. Pervious surface is available at the discharge point. The discharge location is level or slopes away from the structure, but not so steep that the discharge would cause erosion. And that the discharged water will not create ice on pedestrian walkways or otherwise create a nuisance. And then again, the last tenet of that is that if after disconnection and implementation of all practical on-site stormwater management techniques are put in place, if roof drainage has caused property damage or unsafe conditions, then the reconnection to the combined sewer is allowed. So in this case, there were 4 downspouts identified, and I believe it is only 2 that they are looking for an exemption from. Staff recommends denial of the appeal based on the inspections conducted by Strand, the Planning Development Department, and the Director of Public Works, who have all determined that the minimum threshold for the requirements of the program have been met. Within the packet, we have the initial downspout disconnection notice and report that Strand provided, the email correspondence from the applicant and DPW, and the Board of Appeals application, and pictures provided from the applicant, as well as additional property survey map and pictures.
We can get clarification from the homeowner here, but it appears that the request is relating to the northeast and the northwest downspouts? Okay. And there's photography available on, starting on page 37 for the northeast and northwest downspouts. Okay, questions for Inspector Burris before we proceed to homeowner statement? For the, either the northeast corner or the south or the northwest corner of the structure, is there 5 feet, 5 feet, 5 feet from the downspout to the adjacent property line? It's unclear here whether there is. or
Sure.
not.
So I suppose it should be taken in consideration that the majority of all of these reports that were sent out is that the setback requirement for a house is 3 feet. In most cases, one side of the house will only ever be 3 feet from the lot line. And so, while I'll say the north side of this house is 3 feet from the lot line, but say at the northeast corner, that is at the front yard. And so the position is that that downspout could be taken into the front yard and could then it be directed, and the program doesn't require that it's 5 feet from a neighbor's lot line. It's 5 feet from a foundation wall or basement. And so we can get it 5 feet from the foundation of the house into the front yard. And whether it's 3 feet or 2 feet from the lot line, again, it's in every case, again, when the house is only 3 feet from the lot line and the downspouts on the corner of the house, the presumption is that it may only be 3 feet from the lot line, but it is going to be 5 feet from the foundation.
But it seems as though the language of the zoning regulation, the MMSD 3.107 3A2, that's on page 34. Sufficient space is available to locate the discharge point at least 5 feet away from basement or foundation walls and property lines. So does that not indicate that the discharge point should be 5 feet away from the property line?
Well, again, it's with the lot lines as close as they are, I'll say this, it's very easy to achieve that, right? So if the downspout is taken straight out and directed, say south towards the yard, then we've achieved that. And in the front yard, that is achievable.
Questions for Inspector Burris? Hearing none. Thank you. Do we have a representative of the property that would like to make a statement? Okay. Just make sure that you're speaking into
Oh,
the
I'm sorry.
microphone and you
So-
are still sworn in. So if you'd like to give us some more information about the 2 downspouts that you would like to keep connected, that would help us.
Okay, so do you have the pictures that I sent?
We do have.
So you
pictures.
see the front yard pictures with the water that's in my neighbor's yard? After rain, there's always a lot of water collecting there. And actually the downspout is 32 inches from the lot line because I actually measured it. And in the backyard, I'm trying to keep my green space, my rhubarb and my raspberries. And there's no room for a downspout there because if I put a downspout there, there's no room for me to walk and cut those things and use those things. You'll see that it's just a narrow walk. The fence is not mine. And anyway, wouldn't go over the fence anyway. So it's just as a matter of, maintaining my yard. I've lived there 41 years. I maintain my yard all the time and do everything. And I don't want all that water to go in my neighbor's yard. And I also want to maintain my garden space.
And so for our purposes, can you confirm that there are 4 downspouts on the property,
Correct.
but the only ones that we're concerned about are the ones on the north side of the
That's
property?
correct. Yeah.
Okay.
They're the ones next to my neighbors and they're 32 inches from the property line.
Okay.
Yeah.
And so for the north, let's see. It appears that the northeast downspout is towards the front yard of the home. Is
That's
that correct?
That's correct. Mhm.
Is it possible for an extension to run from the downspout to the front yard? Do you think that is feasible for
It
that
could.
downspout?
I thought it had to be 5 feet from the neighbor's property, which would make it go then across my front lawn. And then if that's there, how do you, this is just a question I have. How do you mow the lawn and do that kind of stuff if you have to lift the downspout?
Right, so if it's at the corner,
It's on, mhm,
it would have to make a U-turn
correct,
and kind of go diagonally
correct, across the front lawn.
and
Mhm.
across such that it would be 5 feet from the basement or foundation walls as well.
Yeah.
Okay.
Mhm.
And so you have lawn space in the front of the home, okay, that you
yeah.
mow? Okay. All right. And then the northwest corner, again, close to the adjacent property lines, and there's some gardening and
You
fence
can, you
area.
can see the path is about this wide to walk down to where the rhubarb is and the raspberries and the tomatoes and all that kind of stuff.
Okay,
So to put a downspout down there, it would actually be, people might trip over it. I might trip over it, actually.
all right, questions for
Mhm.
our homeowner relating to these two downspouts?
Are there any, is there hazard created? In terms of ice, anything that might become a detriment? Any hazard by disconnect?
No,
So on the north side of the property, there isn't a it's not right up against a walkway.
no, there's no walkway.
So it's mostly aesthetic, it's all aesthetic, not material to the structure.
No, it's all like plants and gardening stuff and mulch. But there's no hard concrete, no.
Was there a statement from your neighbors to the north? Is that what it was?
Yeah, yeah, no, they did know I was coming. They just have clients and stuff, but
Okay.
yeah.
Did they, that water that you've taken the picture of, what part of the house is that?
That's the front lawn.
Their front lawn?
That's their front lawn.
And they're disconnected on that.
That's correct, they are. Mhm. I think they had to disconnect after that flood or something. They told me.
Further questions for the homeowner? Any further statement you'd like to provide us?
That's,
Well, thank you very much.
thank you.
Okay, I'll move to proceed into deliberation. Do I have a second?
I second.
Okay. So I'll clarify just at the onset, the standard of whether, this meets the criteria for granting, an appeal for interpretation to allow. As the village attorney has advised us, this is a deferential review to the village's decision, where we're looking for substantial evidence to support the village's conclusion, and in this case would be ordering disconnection. Our village attorney has advised that the substantial evidence test does not require a preponderance of the evidence, but merely that reasonable minds could arrive at the same conclusion as the administrative body here, the village, based upon the record before it. So here we're looking to evaluate whether there is any substantial evidence to support the village's determination here. Any initial impressions as to whether the village had substantial evidence to support this disconnection order, looking at to whether reasonable minds could arrive at that same decision?
I could see that reasonable minds would come to the decision that you could actually divert from that corner of the house. But with the partial evidence here of what's in the neighbor's yard from their disconnection at that same spot right now, shows that there's appears to be drainage issue to begin with. Compounded, they're actually appear to be on the lower side. Doesn't matter how much further you put it into the front of the house.
And that would relate to the northeast corner
Correct.
in the front yard. Right, this is a deferential review to whether the evidence considered by the village was substantial, such that reasonable minds could come to the same conclusion that disconnection was warranted. And again, we're looking at those 5 criteria on page 34. I acknowledge that there is some very, very close property lines, but as it appears that one could divert the disconnection through a hose and run it through the front yard or through the backyard, and all that appears to be inconvenient for the property owner. It seems like it's possible to divert it away from foundation and basement walls and the nearby property lines. Well, we've closed testimony, but if there is something you would like to provide us that you haven't mentioned before, you can come back up to the podium to say it.
And back here, it's almost impossible to put something there because it would have to go up over the garden wall. You know, it can't go straight because there's no place then to.
How
go.
high is the garden wall?
Well, it's about a foot. So it would have to go, and then it would be in the garden, and then I wouldn't have tomatoes and that.
Okay, thank you. Other thoughts?
This one's difficult for me. Conclusion that
I tend to agree that if we were allowed to take into consideration other factors, such like when we're looking at variances, perhaps this would be a closer call. But I would tend to defer to the decision of the village that these downspouts do meet the criteria for disconnection, and that's a reasonable determination.
But my question is, so when you talk about the standard, not a variance, tell me if I'm interpreting, you're starting with ordinance, something that legally established disconnect downspouts in DMM. Wastewater. Because that would increase, put an additional burden. But then you start with the dictum, then you have to back through various situations. So in essence, you are looking at a variance. I understand how you're interpreting it, but it is, if you interpret the law ordinance as written, probably no contest. But if you are looking at a variance, you could make exception for a lot of these. And what you're suggesting is that it was not sent here, the variance, it was sent here black and white on letter of the law. That
I would say that we have been advised by the village attorney that challenges to orders for disconnection relating to this program are governed by a deferential standard where we're looking at a challenge to the interpretation by the village.
Yep.
And that standard is unfortunately not the same as what we would use for a variance. Instead, that we are looking to see whether there's substantial evidence relied on by the village that could come to this same reasonable conclusion.
So then the question is it procedural for the applicant to come back and present request for a variance? Because you went through this in the beginning of the preamble, that this is not a variance.
The reason for that is because the village attorney has advised we do not have jurisdiction to hear this type of request as a variance.
Okay,
So she could come back and say this actually is a variance, but we would get the same advice from the attorney or village attorney that we cannot hear it as a variance.
is there an additional remedy for take up? Just trying to,
Yeah, do you mean if we do not make a decision? I don't know the answer to that.
The decision.
I do not know what the next step of appeal after this would be. There might be further appeal available, but I can't say for sure.
I mean, personally, I'm sympathetic to what is
Yeah.
presented here.
Yeah.
I am. But I'm also understanding the legal ramification, claim that we do not authority to handle this.
Right.
Maybe that ought to be deferred until further interpretation is given by, to go back to the village attorney. We have a problem here. How do we resolve? Because they need to be heard, and it has to be done, in a humanitarian, not just.
Well, I do not feel comfortable with ignoring the guidance we've received from the village attorney. If the applicant wants to remove their request and not have it be determined, they can certainly do that. But I'm not sure if we have justification for just saying that we're not going to decide the matter. Although we certainly could postpone it if we wanted to have the village attorney here at a future date, but I'm just not sure if that's really justified at this time.
I believe that actually we would have to postpone it because she did come in here for a variance. And started out with our legal proceedings as to changing it from a variance,
But the thing
just
is,
under legal counsel. Yeah, I mean, it's a ticky-tacky situation, right?
thing is, if legal counsel was here and, will present variance, our option is to we just would not have heard. So our options are to continue as we have been and vote on it.
An appeal for interpretation
Yeah,
to
or
allow.
appeal for allow, or, retract and say she wants the variance. We just can't.
And this is not a matter of first impression. We've had these types of
Yeah.
downspout disconnection things before. We have, I believe, emails sent from council to at least some of the members on the board about the standard that applies.
Would not deviate from that at this.
I mean, I'm, as a former homeowner, I'm very sympathetic to things that homeowners go through. They're all different, and everybody's got a story. Compelling, that could be considered. You're running into just black or white, yes or no. Difficult, because there's a story here.
Sure.
So I'm trying to be helpful to the homeowner, having you or us provide some guidance might get the situation solved, or we just vote and whatever happens. I mean, that's kind of where.
I don't think that the board has the authority to ignore the standard that we've been advised by the village attorney. So for me, if this matter proceeds as an appeal for interpretation to allow, then we have a stated standard to apply. We vote on that, and then the homeowner may be able to pursue some other further appeal. But I don't feel like it's within my authority to say that variance standards apply unless the village attorney has advised that, and that's exactly not what the village attorney has advised. Okay. With that being said, are we ready to proceed to a motion? And would anyone like to make a motion relating to this matter?
Or
Or,
does the think that's,
Right. Does I suppose, would the homeowner like to proceed for the board to vote on the interpretation of the village's decision here? Or knowing that if this is a variance, I'd like to proceed as a variance, that the board does not have jurisdiction over that type of request for this matter. I know we're getting back into legal jargon here. Does the homeowner have any statement they'd like to provide?
Help me, but it's very confusing. Maybe if I could just disconnect the one on the east and leave the one on the west, that would even be helpful. I mean, you know, that would be helpful. I don't think I want to go to another appeal that's just this like crazy.
Okay, so
But I appreciate your saying that.
so we will proceed with a vote on the appeal for interpretation to allow. Is that correct? You'd like to proceed? Okay. Would someone like to make a motion on this matter?
the,
I'll make a motion to grant the appeal to the MSD prohibited connection 0.107 Amendment B.
I think it might be better to cite to our own ordinances, which is on the first page of the agenda. So the MMSD criteria are incorporated into our village ordinance at 225-6 and 415-18. I don't want to be a stickler, but
So we are making a motion to grant the appeal to the Village Code 225-6 and 4-15 or 415-18.
at
Yeah, at 3515 North Murray Avenue.
okay, any second for that motion to grant? All right. So just for clarification, this motion would be to grant the applicant's appeal and essentially overturn the decision of the village, right, relating to the northwest and northeast downspouts. Toya, would you like to call a vote?
John Tutenhoff,
Aye.
Cara Espera,
no,
Wendy Smith,
No.
Stephen Isaacson.
Aye.
Motion
Failed.
failed by
With
a
a
tie
split-
vote,
tie
yeah, by a
vote, it
split
fails.
vote of 2-2.
The village clerk will send notification about the results of this vote. This vote was 2-2, and with no majority, the motion fails, which means that the applicant or homeowner does not have their decision overturned. So the decision will stand to disconnect those two downspouts. All right, our final matter is item number 9, request for a variance of Village Codes 225-8B2, 4 and 7, and 535-19E sub 4 at the property 2224 East Capitol Drive. Let's see. Trying trying to find where in our packet we are. 62. Thank you. Okay, and to reiterate, this is a request for a variance, and we have had our variance standard applied earlier, but just as a refresher, for granting of a variance, where the request will not be contrary to public interest where owing to special conditions, literal enforcement will result in practical difficulty or unnecessary hardship, such that the spirit and the purpose of the municipal zoning code shall be observed and the public safety, welfare, and justice secured. The two criteria in which we need to find is exceptional, extraordinary, or unusual circumstances or conditions applying to the lot, parcel, or structure that don't apply generally to other properties in the same district. And granting the variance would not be of so general or recurrent nature as to suggest that the zoning code chapter should be changed. And the variance will not create substantial detriment to adjacent property or materially impair or be contrary to the purpose and spirit of the zoning code chapter or the public interest. Beginning with a statement of the village. Inspector Burris, can you provide us with some information relating to this request at 2224 East Capitol Drive?
Yes, thank you. St. Robert's Congregation applied for a building permit to make site improvements that include the replacement of a chain link fence along the east side of the property along Farwell Avenue and resurfacing the playground and parking lot that serves both the school and the church. And the village received the building permit application on April 22nd, 2024. Given the complexity of the site and applicable provisions of the zoning code, multiple conversations have gone on between the village and the applicant. And eventually a denial letter was issued on May 17th and a Board of Appeals application was received on June 21st. The property is located in the P1 district and it is situated across 4 separate parcels. There's a map in the packet that will illustrate this. So technically, each individual parcel is required to have its own, it would require its own permit application and is subject to the zoning regulations as a standalone property. Given the unique circumstance and upon agreement with the applicant, the village decided to consider this application across those 4 parcels as a single project and require only one permit. It is understood that should this project move forward and a building permit be issued, it would be issued with the condition that the 4 parcels are combined into a single parcel with one common tax ID to kind of eliminate some of the confusion. With respect to the fence variance, the fence portion of the project was denied based on 2258 for a number of factors in that it exceeds the maximum height limitations for both front and street side yards. The current fence fronting North Farwell Avenue is 4 feet in height, and the proposed new fence in that location is 10 feet in height. Let's see. The application was also denied based on the material chain link, and that chain link is only permitted in residential R districts, side and rear yards, and the property at hand here is zoned in the civic or institutional P district. The parking lot buffer variance. So again, the parcels themselves are legal non-conforming in that there is an existing parking lot that doesn't have any of the required buffers. When a structure, the parking lot, is replaced or modified, it shall be made to conform to the current zoning regulations. So we did not receive plans detailing the required buffers and is seeking the variance that their installation shouldn't be required at all. Yeah, so it is that essentially the variance for the buffers is to to suggest that they ought not be required, given the circumstances of the property.
What is the norm?
So in the packet, and these buffer requirements, were modified or increased with the zoning code update.
Oh,
And so in the packet, I have included the buffer requirements. They're somewhat extensive. And there are some visual aids in the code that help explain it. But there are depth requirements for buffers, specific, plantings and things there. It gets pretty weedy. On page 66 of the packet, is a map that shows the area of, as we understand it, the St. Robert's School and Church on one parcel, and then the parking lot playground area are the 3 parcels behind that. We're gonna say, so Village Code 53549 establishes general requirements for all parking areas and states, the premise shall be screened from any public street upon which it abuts or from any adjoining residential property except for openings for ingress and egress. Such screening as required must be reviewed by the design review. So this again, if the determination is made that the screening isn't required, then it would not be reviewed by the design review board. There are frontage buffer requirements. These requirements are intended to lessen the visual impact on this of the site of vehicular traffic, loading or other activities from the street. They are specifically required along the perimeter of any off-street surface parking, driveway, loading, fuel pump, drive-through, or other vehicular areas that front a street, right of way, not including an alley. And then there are also side and rear buffer requirements, and those are intended to minimize the impact that a zoning district may have on a neighboring district. So again, we're P1 and it neighbors a residential district. So to limit the impact it has on neighboring districts and provide a transition between them. So again, in the packet, we have the buffer requirements that more or less illustrate. And the applicant will speak to, there are existing buffers that those pictures will illustrate. It is more that the initial application didn't include anything, one, to demonstrate that these buffers complied with the current requirements. And it is known that the buffer on the north side of the property, there's some very tall arborvitae. Those are actually on the neighboring property. So they're not on the St. Robert's property. Provides a buffer nonetheless. Staff's final comments are that staff acknowledges there are unique conditions that exist at this subject property. Specifically that the lot is used as a school playground and a parking lot for the church at times. If site conditions warrant, variances to install the 10-foot chain link fence along Farwell Avenue and to eliminate the required lot buffers should be granted.
All right, so for clarification, it appears that we have 3 different issues here. 1, the height of the proposed fence. 2, the material of the proposed fence, the chain link,
Yes,
and the buffer issue.
yes.
I have a question about the buffers. Is it the village's interpretation that the frontage buffer applies to the street side strip of the property along Farwell Avenue?
Correct.
Okay. And then the side and rear buffers apply to the other neighboring, I guess, I don't know if they're north, south, east or west, but
Yeah.
the other side of the parking lot neighboring residential properties.
Right.
Okay.
Yes. Yeah, and so what, again, further complicates things, but what should be clarified through, say, a quitclaim deed to combine these parcels into one is that, so the St. Robert's property on Capitol Drive has its own, the front yard would be on, say, Capitol Drive. As we get to Farwell, you have 3 parcels that have a front yard, if you will, on Farwell. So the height requirement for front yard fence is maximum 4 foot. But once it's combined into one parcel, that would be the street side yard. So I don't know that much consideration needs to, take place, maybe just more an overall arching view of this as, as it would be one. So makes things a little bit easier.
Questions for Inspector Burris?
So they already have a variance on all 3 of those parcels, huh? That was
No,
granted to them or?
legal non-conforming. We have a number of these situations in the village where some of the school properties are on more than one parcel. We're running through the middle of a building. It makes no sense at all. It's
Because they're definitely in violation of also the 30% rule of open space that we dealt with earlier.
so this is in the P1 district. And so it is the residential districts that are required to have that 30%.
So is there no
commercial
additional
and-
green space requirement for this particular
Correct.
group of properties?
Yes.
Okay.
We're looking at 3 different.
Yes.
Because the property owners have
Agreed.
tentatively agreed to
Yes.
consolidate the properties for the purposes of taxation, tax ID, or
Yes.
something to that nature?
Yeah.
Okay.
Fence.
So there is a 4-foot fence along Farwell currently. Again, as it's used as the playground, there are basketball hoops along that fence line. And some of the pictures in the packet illustrate there are on a daily basis balls that make their way onto Farwell. And that's the purpose behind the taller fence.
The 4 foot.
Yeah. It is.
But on page 79, it's 10 foot. Wondering is what's going to be there?
That's what's being proposed. Yeah.
What foot?
Further questions for Inspector Burris at this time? Hearing none. Do we have a representative of the property owners that'd like to come up and make a statement at the podium, please?
Can you raise your right hand? Do you affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Dan Wickland, 2212 East Menlo Boulevard in Shorewood, not Milwaukee, although
And what's your relationship to the property owners here?
I'm on the finance.
Okay.
So first of all, the village has been really pleasant to work with on this. It was a complicated situation that we learned. We went about this to resurface the parking lot because the parking lot is in a little disrepair. It could last a few more years, but it does need to be resurfaced. So maybe I can take the 2 issues separately. First, the parking lot. We aren't expanding the footprint of the parking lot at all whatsoever. This is just a resurfacing of the parking lot, fixing the cracks by taking off a layer of it and then repainting the lines. So we're not trying to expand the parking lot in any way. We're not trying to change it. St. Robert has been there for over 100 years, and obviously ordinances, things change over time. And we're not looking to push back on a lot of this, except for the fact that to conform would be almost impossible and still use as a playground. You look at those pictures in the packet, I think it was page 85. I went on GIS and just printed out some historical pictures. We call it a parking lot, like Justin said, but if you look like 1985, 1990, there weren't even any parking lines on here. It's a very unique property. If you look at the P1 district compared to Atwater, for instance, And we'd love to have a lot of green space. In fact, people always say, wow, we need green space, but that's not something you can just create. It's always been used as a playground. Kids do their gym classes out there, recesses out there. But the church does have services on the weekends. So if you look in the 2000s, lines were painted. I think cars were always kind of going on the parking lot on the weekends, but it made sense to paint lines and they could exist with the playground lines. And if you look at some of those new renderings, again, we're going to incorporate those things together again. So for the parking lot, it's just a resurfacing, not trying to change it in any way, just resurface it and improve it. For the fence, as Justin said, a 4-foot fence exists there. That 4-foot fence, we're trying to raise to 10 for safety issues. And the property is unique as a playground. If you look at Atwater, same tennis courts are right by the street there. Those are, I believe, 10-foot fences there as well. Because if you're playing tennis in there and there's a 4-foot fence, it doesn't make a lot of sense. I mean, there'd be balls everywhere. And that's the case here, as you see from the pictures. You drive by there any weekday during school. The neighbors have cited as a safety issue. These balls keep coming over. Cars are driving through there. Kids don't run out there. We control that pretty well at St. Robert, but at the same time, those balls do have to get retrieved and they kind of live. So we're looking to put the same type of fence, a chain link fence up there. That's what's existing now. Wrapping the rest of the parking lot as well is a 10-foot chain link fence against the neighbors, so balls don't go in the neighbor's yard. As far as the buffer goes on the parking lot, like Justin said, there is an existing buffer there. There are shrubs that you can see, the smaller shrubs, and there's also the shade trees that were planted a long time ago to comply with whatever the ordinance was. So again, we're just looking to resurface the lot, put the chain link fence up a little higher for safety issues. And it is a unique property as it's used for a school and it's kind of compact work. So we'd appreciate any.
All right. For one, thank you for being with us for so long. It's
Oh,
an
fantastic.
unusually busy evening for the Board of Appeals. Is there any specific reason why you select a 10-foot fence as opposed to say an 8-foot or a 6-foot? Or so what's the rationale behind the 10-foot? Because that is a very high fence.
Yeah, one, it matches the rest of the property. They're all 10-foot fences. Also, that's where basketball hoops are. And unfortunately, a rim is 10 feet high. So by having a 10-foot fence, again, it's about 4 feet back from the backboard. You're eliminating those balls that are going to that.
Got it.
Are the basketball basketball hoops? I know, really big into sport. Are they situated all around the parking lot, or are they in a certain area?
They're on that side there, just on that side of.
Would it be possible to have a fence or fence throughout the rest?
Well, again, there's a 10-foot fence existing on the other sides already, and it's not, I use basketball as the example of 10-foot, but there's kickball, there's all the other things. The balls are bouncing everywhere. You'd be surprised at what ends up over the fence. A 10-foot fence, I mean, we don't want to build a 40-foot fence. We're looking to match the rest of the property and build 10. And if you look at these similar P1 properties where they have balls in play like that, again, it seems to be a 10-foot fence seems.
Is the proposed chain link, is that just kind of your standard metal chain link, or is it coated, or does it look?
It's a
nice?
coated chain link fence. I mean, you know, I believe they sell just plain metal ones, but this is a coated one that's going there. That's what's around the rest of the lot. And again, we're paying to have it match the existing ones that are there.
Okay.
If you look at the trees there too, as you go up with it may not be in the renderings, but if you look at those pictures I took, the shade trees do cover a good portion of that. So as you go up with the fence, it's not like that's really visible to anyone on the outside. And I think we had at least one neighbor write a letter of support for this. They're directly across the street, I believe. Again, this is something the neighbors have wanted in the area because it just improves the, not necessarily for us, because we can go chase the balls, but for the safety of everybody.
So is it, the proposal won't interfere with any existing trees or shrubs or green space that's currently in place? So you're not
No,
going to
we're,
chop down?
again,
any
we're
tree?
not interfering with any green space. We're not expanding any green space. It's just refinishing the lot and moving the fence higher.
The shade trees and the shrubs, those are not on Robert's property,
Those are on the St. Robert.
are on zero.
If you're looking at the ones that are showing that 4-foot fence looking into the lot, they are. The ones that Justin referred to that aren't are the arborvitaes that border the residential properties around there.
Oh, okay.
Again, the fence on there is on the property line. And so those belong to the neighbor.
I see.
You said there's testimony from one of the neighbors. There's eight across the street, there's one of the neighbors is the one that said that there's balls ending up in their yard?
No, I think they just wrote a letter of support.
On page 96.
Right.
And by the way, they didn't solicit that letter of support. They must have gotten the notice and they provided it.
I spoke with her today too.
And it doesn't appear that we have any other materials from neighbors that object. Okay. Any further questions for our applicant? Hearing none. Any further statement you'd like to make?
No, I appreciate it.
All right, thank you.
Thank you.
Perhaps a clarification from Justin. In order to fully comply with the buffer requirements, would that require the property owners to destroy or dismantle any portion of the existing blacktop?
So for the frontage buffer, no. So I did go out and measure, and the frontage buffer is only required 5-foot depth, and they actually have about 7 feet. So again, those trees and shrubs and things that they have there. I would say that again, haven't gone into a full review of that, but they're probably compliant with the frontage buffer along Farwell as it stands. And that one of the additional requirements is to have a fence in that frontage buffer. So they would have to, for the rear and side yard buffers, they would have to encroach in on their property and reduce the size of their lot, the paved area of the playground and parking lot to comply with those requirements.
I see. Any further questions or comments before we enter into deliberation?
Are there any rules of use? I guess, I mean, both the parking lot and the playground. So are there like considerations?
And well, and so as it has been explained before, is that is this property unlike others in the same district, right? So yes, when you look at Atwater or Lake Bluff or the high school, all of those properties have separate parking lots and playground areas. So if they were to repave theirs and they're made to comply with the buffer requirements, it's easier for them because theirs serves as only a parking lot. But yeah, this one, it really is only, I'd say it's more playground than parking lot because it's, out church on Sundays and then, a number of other, events and things. But it is, say, unique from other E1 district properties in that the dual use.
But both Lake Bluff and Atwater don't have 10-foot fences around their basketball.
Well, again, because they have more area available, that they have separate playground areas. And Atwater does have a 10-foot fence around their tennis court.
That one, those 2 tennis courts.
Yeah.
Yeah.
Mhm. Yeah.
One spot.
Hearing no further questions, I'll move to close testimony portion of this matter and enter into deliberation. Do I have a second? Thank you. All right, so our standard here is one for a variance where we're looking for some exceptional, extraordinary, or unusual circumstances applying to this consolidated group of parcels. To find that a variance should be granted. It does not appear that we have any evidence to suggest objection from adjacent properties. And it does seem like this is a unique collection of properties in that it's used by a school for dual purposes of a playground, sports area, and a parking lot. It does certainly seem like this has unique circumstances relating to the law itself that may justify granting of a variance. Further comments or ideas?
No, I tend to agree. The fence and offer very detrimental to use that's existing. Can be advantage of the spaces they do.
But there's one.
Huh?
There's one neighbor over a course of 100 years. There's one neighbor that's complained about balls in the street over 100 years.
Well, I mean, from the pictures too, like, I don't necessarily know you.
Well, I don't either.
But,
You
yeah.
just mentioned that there was a complaint.
Oh,
Saying
no,
that
no, sorry.
I'm
I
not
meant-
trying to
No.
say it's not that big of a.
No, I meant I think people would, I mean, if I lived in that area.
A 10-foot fence or
Well, no, I would rather. If we're able to do that around. Basketball.
would we be setting a precedence then for other people that actually want to age in balls and kids at play? 10-foot wise, I believe there was actually somebody across the street from there that that would have liked a 10-foot fence in front of their house.
But that's the house.
I
Which
think
I
it's
know.
case by.
Yeah, I mean,
Well, I suppose that the adjacent properties, if they're properly noticed with this proposed fence, they would have had the opportunity to object. We haven't received any objections from the neighboring properties objecting to say the 10-foot height of the fence. It's been demonstrated to be used as a basketball court sports type area. For the purpose of safety of the cars and other pedestrians, I could see how a 10-foot fence would be adequate to contain balls flying to and fro and to keep them inside the property. However, I mean, I get the point that if I were across the street, it would be kind of like looking into a prison to see a big 10-foot fence there.
Well, but you have conforming aesthetics. Fences conform aesthetically.
No. Nobody,
Right,
no, there.
Oh,
That's the back part of the property.
Or was there an aesthetic?
We're talking about the front part of the property.
we maybe take
Would it
those
be?
piece by piece, like height of the fence. Material of the fence.
That might be a good idea.
Yeah, just to-
So if we
just 'cause we're
keep it on
crossing.
track.
Yeah,
So, well, how about if we start, we have 3 different considerations here. 1, the height of the fence. 2, the material of the fence. And 3, any questions about violation of buffer zones, which, at least for the frontage yard, doesn't sound like it's much of an issue, but we'll get to that. So first, we'll discuss the height of the fence. It's currently 4 foot, proposed to be 10 foot. For the proposed use, a 10-foot fence does seem, I'm not sure it's necessary to contain balls, but the applicant's assertion is that a 10-foot fence is most appropriate for an area that where basketball is being played.
It's the same height as the backboard,
Yeah, right, or the rim, I believe.
the rim.
So given that we have this property that has dual uses of both parking lot and basketball court, I would think that that's an exceptional circumstance relating to this particular group of properties that doesn't generally apply to other properties in the same district. Is P1 district specific to what type of property?
Yeah, again, civic and institutional. So all the parks and schools and are all P1 districts.
Okay. I do see how one could argue that a 10-foot fence, especially along the frontage area, could be unsightly.
But you-
That's my only consideration is a big black chain link fence replacing a 4-foot chain link fence is a significant deviation from what it currently exists.
But notice was given to the neighbors, they could have objected.
That's true.
Right.
Yes. Are we satisfied that this is sufficiently unique of a property to justify the increase of the fence a full 6 feet above the stated requirement? Do we have we've exited testimony phase, but if there's something material you'd like to share with us, please feel free to do so.
That water. Probably more frontage than water fence and tennis courts is, and closer to the sidewalk in St. Ron. So if you're looking at the neighbors that impacts also without a buffer on it. I don't believe there's the buffer on the street side because you can see right courts. In addition, they hang a green thing on there. I think it's to help with noise from that. So again, these things exist through the village in similar properties, but ours is even more unique. Again, that is our only playground. Can't take it somewhere else. It's got to be there. And again, we're trying to do this for the safety.
Thank
Are
you.
there more basketball hoops that are being proposed?
No. And again, like I said, I use the basketball as the 10-foot. Maybe that's a bad example, but again, it's kickball. They play volleyball. They throw balls around. It's football. If you look in the street on any given weekday, it's a hodgepodge of balls that have been there. It's unfortunate that they do. I mean, we wish they didn't, but it just happens. And this is.
Thank you. I also think it is helpful to know that there are some existing tall trees that could screen the visual impact of that 10-foot chain link fence. Those will still continue to exist, and for the period of time which they have leaves on them, that could help to block any kind of visual disturbance. Do we want to do a motion per element or per
Just I think we could package it.
package? Okay. Well, then, if there's no further discussion on the height of the fence, let's talk about the material of the fence. Per the inspector, in this particular district, chain link is not allowed, correct? But this is replacing an existing chain
Correct.
link. Okay. And per the testimony of the applicant, this is a coated chain link fence being proposed.
It is.
So that's like,
And I believe that the purpose of using chain link is that it is less visually impactful because it is mostly open. So,
Yeah, a 10-foot wood fence would be
Right.
quite
yeah, yeah,
like
Mhm.
fortress-like.
yes.
Yeah.
okay.
I mean, it seems as though coated chain link is appropriate for parking lots and sports areas. I mean, we don't have any evidence to suggest a different material would be more appropriate. Thoughts on the material? All right, let's move on to the last element on the frontage and side and rear buffer requirements. As the inspector has said, there is a 5-foot frontage requirement and a 3-foot side and rear buffer requirement. It's a little bit unclear, but it seems as though the village may not object to the property as it currently is in terms of the frontage buffer. But that it appears that the proposed fence would infringe on the side and rear buffer requirements. Is that correct?
It isn't that the fence is that if they were required to have the side and rear buffers, yeah, it would encroach into the current area of that lot.
And that would require removal of some of the
Yes.
pavement of the parking lot.
Yes.
Okay. And the existing fence? Or, excuse me, I think fence can exist within a buffer. Is that
yes.
correct? But the pavement itself would have to be removed.
Yes.
So
Yes. Right. Three feet.
doesn't,
Correct. It doesn't exist on this property. Yes.
There-
There are clearly vegetative buffers on the neighboring.
the neighbor,
Yep.
yes, what if those? I mean,
It would really only cause issue for the neighbor that did it. It would, yeah, I mean, again, understanding someone purchased the house next to this property. Again, if they wanted to remove them, absolutely, that would be their option, but you'd think that
yeah,
And for clarification, for the side and rear fence lines, are those, what's the current height of those fences on the side and the rear?
yeah, I do believe those are 10 feet.
Okay, so those are existing 10 feet.
Yep.
Yeah, those property owners have already taken the idea of hiding the 10-foot fence and have taken the obligation of putting up the greenery, what we're
Uh,
saying, right?
Yeah, I'm sure.
are those 10?
No, those fences are not being touched. Only along.
Okay, so if we think that the front. Because if we're not making any
So-
changes to the side.
That in replacing the parking lot, we're saying it would be giving them a variance to say, we're not going to make you require those buffers.
So
And-
it leaves them more space for.
Yeah, my question was, they're not actually,
Correct.
rear.
There's no proposed change.
yeah, so if we were to say,
Right, so it's currently legal non-conforming
Yes.
because of the recent update to the code requiring buffer and vegetation and
Yes.
these types of things. Okay. So for them to proceed then, you're right. So if we didn't grant a variance for the buffers, they would have to remove areas of the parking lot in order to fully comply with the buffer zone.
But they're legal non-conforming yard.
Yes.
You have to touch that or.
Another further comment if it's material? Yes.
Yeah, this was the thing we figured out. Resurfacing the parking lot triggered this in general. So if we couldn't get that, we couldn't. That's what's. So again, no plan changes to footprint to address that. It's
Right, so I think if you've just kept the parking lot as is, that side and rear buffer zones, could continue indefinitely as legal non-conforming.
Oh, most definitely.
But because they're, doing some work on the pavement itself, that's where this comes into play,
So the real issue here is
essentially. Yeah. Okay, thank you. Okay. Further comments? Hearing none. This is gonna be a real messy motion here. Okay, so perhaps, We might just want to do 3 motions because otherwise it's going to be a run-on sentence. Okay, I don't mind proposing a motion. The first of 3 motions. I move to grant a variance of the Village Codes 2258B sub 2, sub 4, and sub 7, and 535-19E4 at 2224 East Capitol Drive, including the parceled lots to be considered one parcel of properties. To grant the variance allowing the replacement of an existing 4-foot fence along the frontage side of the lots with a 10-foot fence. Thank you. Toya, can you call a vote? I'm sorry if that was complicated. for you.
Okay, I got it. Excuse me. Wendy Smith,
Aye.
Stephen Isaacson,
Aye.
Kara Espera,
Aye.
John Tutenhoff.
Nay.
Motion carried 3-1.
Second motion, I'll move to grant a variance of Village Codes 225-8B 2, 4, and 7, and 535-19E4 at the consolidated properties at 224 East Capitol Drive, to allow the replaced fencing to be made of a material of coated chain link. Do I have a second?
Second.
Got it.
Can you call a vote, please?
Kara Espera,
Aye.
Wendy Smith,
Aye.
John Tutenhoff,
Aye.
Stephen Isaacson.
Aye.
Motion carried 4-0.
The final motion, I will move to grant a variance of Village Codes 2258B2, 4, and 7, and 535-19E4 at the consolidated parcels at 2224 East Capitol Drive, such as necessary to construct, hold on. Don't use those last few words.
Okay.
Okay, to grant the variance at the consolidated properties at 224 East Capitol Drive. To eliminate the buffer requirements at both the frontage and side and rear areas of the consolidated properties.
Would you say continuing? Non-conforming
In its
continuation.
in its current legal nonconforming state. Can you tack that onto the end? I can look at it if you don't want me to.
Got it.
You got it?
Mhm.
Okay, does that make sense? Okay.
I second.
Toya, can you call a vote, please?
Stephen Isaacson,
Aye.
Wendy Smith,
Aye.
John Tutenhoff,
Aye.
Kara Espera.
Aye.
Motion carried 4-0.
All right, these motions have been granted. Documentation from the clerk's office will arrive after this meeting. Thank you. Having no other items on our agenda, I'll move to adjourn this meeting. Do I have a second? All right, this meeting is adjourned. Thank you and have a good night.
At 7:33 PM.
Are you related to Alice?